I'm Neil Charnas. I'm the director of the Institute for Successful Longevity. And today we have as a brown bag speaker, something a little bit different, not a faculty member at Florida State University, although I wish she were. Instead, we have one of the Institute for Successful Longevity's Community Advisory Board members, Lauchlin Waldoch. We're very pleased to have her. I'll give you a little bit of background. She's the co-founder, or is a co-founder, of the Tallahassee firm of Waldoch and McConnaughhay, PA. And she devotes her time exclusively to elder law and related issues. Her practice includes wills, trusts, probate, and incapacity planning, including powers of attorney, advanced directives for healthcare, such as living wills, and healthcare surrogate designations. A substantial part of her practice also involves understanding public benefits, particularly as related to long-term care, such as veterans benefits, Medicaid, and managed care. She helps families who care for those with special needs using special needs trusts, protective trusts, and other planning vehicles. And she's certified by the Florida Bar in elder law, and she's a designated certified elder law attorney by the National Elder Law Foundation. She's a co-founder and former chair of the Public Policy Task Force of the Academy of Florida Elder Law Attorneys and chair of the Elder Law section of the Florida Bar. She works with legislative and regulatory issues affecting seniors and persons with disabilities. She received Member of the Year in 1999 and 2005 for the Elder Law section of the Florida Bar, and for the AFELA in 2001 and 2005. She's also very active in numerous national, state, and community organizations related to the elderly and individuals with disabilities. So without further ado, I would like to welcome Lauchlin to talk to us in our ISL brown bag.
Okay, well, thank you, Neil. But as I said before, I only want you to say I'm an elder law attorney that loves what she does. And really, the awards are getting a bit long in the tooth. So I was asked to talk to you guys about incapacity planning, which honestly, as an elder law attorney, is near and dear to my heart. And one of the reasons is because a major aspect of elder law that sets us apart from estate planners, although we do that as well, is exactly that. It's not so much what happens when you die, but if we don't die, or before we die, when we lose capacity, how have we planned for that, or how can we plan for that? And so that's what I want to focus on today. There are various planning vehicles that are available to us. And for me, those of you who have been involved in ISL and have seen their absolutely stunning research over the months and the years will know that they excel in statistics and numbers. Well, that ain't me. I love words and language, but I don't have a lot of statistics for you. But I can look at statutes and rules and regs and interpret them and talk to you about, to a certain extent, stories, but now's not the time for stories. So in preparation for today, I actually went back and read the law. Novel thought, particularly for a lawyer who's been practicing for almost 45 years. So, you just tend to think, well, why would they change that? I know it already. Yeah, that's not such a good idea. But if we take the global, well, not so much global, but the 30,000 foot view perspective initially, what we're really talking about is substitute decision making. And I have to be careful about the language I use, and we'll talk about a little bit about that later. But if you couldn't make your own decisions for whatever reason, short term had to go to the hospital for surgery, or longer term, you had a stroke, how are you going to designate the person or the people to help you, and what ways are we going to plan for that? There are two basic decision-making concepts. One is financial, and one is personal care, medical care, mental health care. Now, those are three broadly stated areas that oftentimes come under the ambit of healthcare. In my world, those are usually captured in two types of documents. In Florida, we have a financial power of attorney, and we have a healthcare document. Now, in some other states, there is a healthcare power of attorney and a financial power of attorney. In Florida, we couldn't possibly make it that easy. So we'll talk about those language differences, and probably that's because lawyers populate the legislature and lawyers don't like to use the same word meaning the same thing. It would make us look too unsmart. Okay, so let's talk about powers of attorney first, because many of the concepts and the words that we use and the ways that powers of attorney are created, amended, revoked will translate to the healthcare documents that we're going to talk about. Before I get into detail, or too much or too little detail on the power of attorney documents, I will talk briefly about trusts, because trusts or certain types of trusts can also be used as incapacity planning tools. As a matter of fact, in my view, that's the main benefit of trusts in Florida as asset management tools in the event of incapacity. So I will touch on those. Today is not, there won't be anywhere near enough time to talk about trusts in that context in any amount of detail. So let's talk about powers of attorney. I will mention the statute that's involved, because particularly in today's world, many of us go to the great God Google and want to look at the actual law, or in medical terms, what's really out there. I know I'm either guilty or praised for that, depending on where I go. So the statute is, it's Florida Statute 709, excuse me, .2101 through 2402. That's Florida statute. Everything I talk about today is very state specific. So one of the questions I get is, Lauchlin, I really enjoyed meeting you, and I'm glad you did my documents, but now I've decided to move to California. Do I need to redo my documents? The answer is yes. Unfortunately, you've got to go see a lawyer out there because it is very state specific. Most states like Florida will recognize a power of attorney or a healthcare document as long as it does not violate the public policy of the state in which you're trying to use it. But please don't rely on that for long, because the state differences are way too significant. So let's talk about the powers of attorney. You will hear the word durable power of attorney. And when I talk about powers of attorney today, I'm talking about durable powers of attorney. Durable power of attorney simply means a power of attorney that you've signed that survives your incapacity. Well, people say, well, duh. That's why I sign a power of attorney, is that somebody can have my have authority once I become incapacitated. However, there are other types of powers of attorney that you might sign if you just wanted one single act or several small acts done, and it didn't matter if you had capacity or not. You're going on vacation, you want somebody to sign a real estate contract, and if you became incapacitated, well, you don't want that contract signed because the world might have shifted under your feet. Those are not durable powers of attorney. But for purposes of this discussion, we're going to be talking about durable powers of attorney because that's the point. There's some definitions that we need to talk about. So I'm only going to mention one or two of those initially in addition to durable. And then we'll talk about other definitions as we go through. One, when it comes to powers of attorney, is third parties. Third parties are the people or institutions that going to ask to rely upon the powers. So it might be a bank, it might be an investment company, it might be your next door neighbor. That's a third party. And the principal is the person making the power. So the principal is, if I'm going to give Neil my power of attorney, I'm the principal, and Neil is then the agent. The agent is the person who is going to be the person to whom I give the power. Sometimes people say, well, he has my power of attorney, so he is the power of attorney. Technically, he's the agent. Doesn't really matter what you say as long as everybody knows what you intend. Who can make a power of attorney? Anybody over the age of 18 with capacity in Florida. 18 is the age of majority in Florida. Who can serve as the agent? Anybody over the age of 18 with capacity, or certain institutions in Florida can serve as agents. Now, there are restrictions on that, but certain institutions can serve as agents. Let's talk about the validity of powers of attorney. We talked earlier about that certain other states will recognize ours and will recognize theirs. There are very, very specific execution requirements in Florida for a power of attorney. And this is one reason why my hair curls even more when I see people come in to see me with powers of attorney that have been pulled off the internet, because many, many times they may be okay, but they're not executed appropriately when it comes to Florida, and we have to say, not so good. The basic execution requirements is that the principal must sign in the presence of 2 witnesses and a notary. That means 2 attesting witnesses and a notary. If the principal is physically unable to sign, that's okay. There is a procedure in Florida where a notary can sign for the principal, but it must be done again with certain procedures. We do it in our office all the time, so it can be done. I'm a notary. Most of the people in my office are notaries, so it can be done. So if somebody says, well, my dad can't sign because he's had a stroke and he can only communicate by winking his left eye, that's okay. We can still do that. Now, if dad's had a stroke and he thinks he's Napoleon, we can't do that. Let's talk about the efficacy of the power. Let's talk about when is it effective? And this is critical again in Florida. In Florida, a power of attorney that is executed after October 1st, 2011, is a live power from the minute you sign it. That bears repeating. It is a live power from the minute you sign it. Before October 1st, 2011, Florida allowed a springing power. What that meant was that I could create a power of attorney for a client that said, I, Lauchlin, want you, Neil, to be my agent, but only if a doctor signed an affidavit that said that I, Lauchlin, lacked capacity. Now that sounds great. That sounds like what everybody would want. In practice, it was a disaster because doctors wouldn't sign affidavits, doctors being skitsy of liability, and the banks and other people that had the third parties that had to rely on it. There were restrictions on what types of doctors could sign the affidavits anyway. Trust me, I'm a lawyer, it didn't work. So as of October 1st, 2011, those went away. If we have a valid power executed before then and we can't get a new one, then we can make those work, but it's not fun. So critical thing is, if somebody comes to me and they say, well, I want a power of attorney, I have to kind of pound into their head, well, that's fine, but you've got to trust the person you give the power of attorney to, because although there are restrictions that we're going to talk about, you still have to trust them because it's a live power from the minute you sign it. Now, please be careful, because even when the power of attorney is done well by a qualified person, The federal government and the state government still don't like to talk to each other. So we do a power of attorney for someone and they go apply for VA benefits. The VA says, not so much, we don't want to talk to you. And so your power of attorney is not going to be recognized. This results in very unhappy clients if we haven't warned them of that in advance, managing expectations. But please understand that it's not my fault that the feds don't talk to the states. But be aware of that. So there are separate powers of attorney for military and for certain state agencies. And although the banks and investment companies have their own separate powers, technically they can't require that in most situations. But if there's a way to get by with making that work, we're happy to accommodate that. Okay, so let's say you've been appointed as an agent, and what do you have to accept that? Do you have to sign something in writing? The answer is no, not usually. Sometimes yes, but very rarely. When you begin to act under your power of attorney, under the power of attorney, that constitutes acceptance. Now, it only constitutes acceptance as far as you act. So if you begin to pay bills, that's all you've done. That doesn't mean you've taken on responsibility for investment management. So there are nuances to this, and somebody should explain that to you as agent before, hopefully before you take it on. But once you do, that's the limit of your responsibility. The use of the power is pretty extensive. When you go to use the power, if you're the agent, understand that a copy is just as good and preferable to the original. If you have the original power of attorney, do not let it go. I'll say that again. Do not let it go. Do not give it to a bank or an investment company. Don't give it to anybody unless a court orders it. Or if you need to use it for a real estate transaction in Florida, that's basically the only time you ever have to let go of an original power of attorney or record it. A copy by statute is as good as the original. How do you terminate it? How does the power of attorney stop? I've told you this is a powerful document. It's going to be live from the minute the principal signs it. How do we stop the power, terminate it? Well, if the principal dies, it stops. A power of attorney in Florida is only good as long as the principal is living. The principal can revoke the power of attorney. The power itself, the document itself, can provide when it terminates. That should be obvious, but I've often overlooked the obvious in my life. We won't go into that in today's discussion. The purpose can be accomplished. So even a durable power of attorney can say, I want this to be for so long, for so many purposes, and then the purpose can go away. Now the agent's authority can terminate. How does the agent's authority terminate? Well, the agent can die. That happens to the best of us. The agent can become incapacitated. The agent can resign. And interestingly, if the agent is the principal's spouse and an action for dissolution or annulment is filed, then that power of attorney is terminated. We are seeing more and more dissolution and annulment actions in elders, and this happens. Now, in some cases, the power of attorney is not terminated. It is suspended. The main time that a power of attorney is suspended is if there's a petition for incapacity filed in a court. So let me back up again to my 30,000-foot view. Powers of attorney and the healthcare documents that we're going to be talking about, the advanced directives for healthcare, are oftentimes referred to as guardianship substitutes. Because when we have those in place, we have voluntarily, when we have capacity, presumably, we have named people who will step in and take over if we lose the ability to make decisions for ourselves. So the theory is that we won't need a judicially supervised intervention and a guardian, which is a person who's supervised by the court, to step in and manage our affairs, because we picked the people who can do that. And so they are called guardianship substitutes. So when we have these documents in place, if somebody comes in later and files a guardianship against my client, I can come in and defend that in most cases by saying, no, 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 no. We don't need the expense and the oversight of a guardian because we have good, solid powers of attorney and healthcare documents. However, because we don't want, from the standpoint of judicial economy, in other words, we don't want judges and agents doing battle at some other level. The statute says that if a petition is filed for guardianship, in most cases, the agent under a power of attorney is suspended, and in some cases, the agent in a healthcare document is suspended. So that's another way, it's the primary way that a power of attorney is suspended. As you can imagine, there are notice requirements in all of the cases that I've talked about. An agent who is a spouse, a child, a grandchild, in some cases it is not suspended, but there are basically lawyer type requirements for that. A power of attorney can also be revoked by having a new power of attorney that expressly revokes it, or a written revocation. Okay, now here's something that many of my agents are very interested in, and that is, well, what do I have to do? What are my duties as an agent? We have to keep in mind that an agent is a fiduciary. That just means a person in a position of trust. A lawyer is a fiduciary, a CPA is a fiduciary, a trustee is a fiduciary. It is just somebody who's held to a higher standard. And any agent who is designated, who takes on their responsibility, must understand that. A critical understanding for an agent under a power of attorney is that they must act in the best interest of their principal. It's called a best interest standard. So I have to act in a way that will help my principal and in their best interest. We're going to contrast that briefly against the healthcare standard when we talk about that in a few minutes. The agent can only act as described in the power of attorney. So I can't somehow go manage investments if that's not authorized in the power. Now, the agent must try to further the principal's estate plan. Sometimes that's not possible, but there are statutory requirements about what the agent must consider. So my agent, when they're acting on behalf of the principal, they can't suddenly come in and say, well, I don't really think she wants to give it to the kids. Let's give it to the Tibetan monks. That might be what the agent wants to do, but that's not what is appropriate. So we have to really look at what the principal has done, what their estate plan is, and work very hard to try to make sure that we are accomplishing the estate plan. And again, there are circumstances that we have to look at. People come to me all the time and say, I don't want to do this. Mom designated me as the agent, but yeah, this is no fun. I don't want to do this anymore. I want to delegate to my sister. Can't do it. Can't do it. Mom can choose a successor agent or a co-agent when she drafts the document, but just because you're delegated as agent, you may not do that. There are certain very narrow exceptions to government agencies and like the IRS and things like that, and certain financial institutions, but they're very narrow. An agent must keep receipts, records of disbursements. You can imagine that. They must keep an inventory of what's in the safe deposit box if they can go in there. They have a duty to act loyally in the sole, for the sole benefit. They cannot create conflicts of interest. So if there's a conflict of interest with the agent, they can't go down that path. They have to act with care and competence, and et cetera. I won't go into all of that. Now, they don't have any duty to disclose to anybody, and indeed they aren't supposed to unless the principal regains capacity, or to a guardian or a court or the people you might imagine. The next question all my agents ask me is, well, what's my liability? And your liability is basically not very much as long as you act in good faith and you did everything I just said to the best of your ability. The power of attorney can actually explicitly give you indemnity and exonerate you as long as you weren't, as long as the principal didn't put that language in there under duress. Well, let's say that you think you've done everything right as an agent and your out-of-town sister comes in and says, oh man, you're really screwing up mom's life and everybody gets their knickers tied up in knots. What do? Well, you can always go to court. There are provisions for filing for judicial relief, as you can imagine, because lawyers drafted all these documents. And if you have to go to court and you prevail, you get fees and costs. And so it's not fun, but you can do that. We don't litigate in my firm, we refer that out. But where this becomes very interesting is when a power of attorney is submitted to a third party. Remember that definition initially? Particularly banks and financial institutions. And without casting any disparaging remarks, they are more inclined to deny powers of attorney than other third parties. And for that reason, the statute is designed to allow them to ask for affidavits. So if you are acting as an agent and you run up against a bank that says, well, you have to sign an affidavit to the don't, it's okay, that's acceptable. There is a type of affidavit that basically you sign as agent that says, well, it hasn't been revoked and I'm still a good person and it hasn't been amended, and you sign that in front of a notary and you send it off and that's fine. But the financial institution has about 4 days to either accept or deny, and they have to give it to you in writing if they deny it. And if they deny it without really pretty significant justification, they get tapped for attorney's fees and costs. And our powers have that in bold writing right up front that you better not do this or we know we can get you where it counts. And I'm not a big one to threaten litigation, but really some of these places, they just, we've talked a lot about, in this first part, we've talked a lot about, well, if you do this, you get that. And if you do, well, none of that works if you don't know what's going on. So the statute is replete with notice provisions. And the notice provisions, I'm not going to bore you with those, but many times when you're acting as the agent, you're required to give notice to someone else. So just be aware of that. And if you're acting as an agent, reach out to someone that knows what they're doing, preferably an elder law attorney, and say, hey, when do I have to give notice to this, that, and the other? That's important. Please do it in writing because memories tend to be selective. At least that's my experience. Let's talk about drafting the power of attorney briefly before we turn to healthcare. A power of attorney, what I would like to be able to draft for you is a power of attorney that said, I, Lauchlin Waldoch, give Neil all the power that I have with respect to my finances as though he was standing in my shoes, world without end, amen. Because that's the way, that's what I want, right? And then if I wanted to make exceptions, I might say, except I don't want him to mess with my horses because I love my horses and Neil doesn't know squat about horses. So I'm going to give that to somebody else. But that would be an illegal power in Florida. Florida's statute says, in addition to the fact that it must be a live power, Florida's statute says that it must be very, 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 and I could go on for another 15 minutes, specific. It has to be express. So our powers of attorney, for example, are 13 or 14 pages long. And before you turn off your Zooms, let me tell you why. It's because of that express requirement. So I tell my clients, and there's a power of attorney that's generated by one of the, there are these companies that, and this is a legitimate company that generates documents that lawyers can use, 50 pages long. Seriously, swear to God, Florida power. The reason is, and the reason is that as to every type of property, investment property, banking property, if we don't say, I give my agent the authority to buy, sell, trade, mortgage, lend, lease, etc., then we're likely to have that power of attorney denied in the real world. I'll give you one brief story. I had a call from an insurance agent within the last 2 years, and the agent said, Lauchlin, your agent's trying to surrender a life insurance policy. And I said, well, it's my policy. We're good. Look at my paragraph number, whatever. I have 4 inches of text related to insurance policies. My agent can buy, sell, trade, insure, do everything. I used every verb I could think of at the time related to insurance policies. And he says, this is some guy in Iowa. And he said, well, Lauchlin, you didn't use the verb surrender. And I looked at it and I said, well, you're right. But clearly the intent of 4 inches of text is that my agent can do anything for the best interest of my client. Well, your statute says it has to be express and specific. So we talked for 15 or 20 minutes and it finally got down to, okay, let me get this straight. You're going to come down here. You're going to come down here and we're going to go in front of my judge in Tallahassee, Florida. And you're going to argue that that language, all that language, the intent, because my client was incapacitated, we couldn't do a new power because I'll always take the easier way out. We're going to argue in front of my judge that all that language, the intent wasn't that they could surrender that policy. Well, I don't know. It's the winter time. It's January. I don't know that I want to come all the way because this was before Zoom. So we finally agreed that in this one instance, he could do that. Well, what did I do? I went right back to my power of attorney and put in the word surrender. And so that's how ridiculous it is. So we have to do that. In addition to which, the last thing I'll tell you about powers of attorney is that in addition to all of that, Florida says that as to at least 8 powers, the principal has to initial yes or no. And those 8 powers have to do with trust making, gifting, certain types of beneficiary designations and joint and survivor types of property. Authority. This is all authority you would give your agent. And disclaimers, powers of appointment, and homestead property. All of which is fine, but we have so many layers of complexity added to our power of attorney statute that it's mind-boggling, and I frankly think it's unfair to the consumer, but personal opinion. Okay, I know we're going to have questions on the power of attorney, and Neil, it's up to you whether we want to do it now or the healthcare will take a little bit less time, but I wanted to dig deep into the power of attorney, so it's up to you.
I think we'll delay taking questions until you have a chance to present the material you intended.
Okay.
And then we'll come back. I'm just going to remind people you can put questions in the chat if you'd like them. And as well, hopefully if we have enough time, we can do this in person. Go ahead.
Yeah. Okay. So the next topic that I wanted to touch on will deal with healthcare. And the healthcare statute, since I promised you I would give you a statutory site, is Chapter 765. And it's 765, basically all of 765. There are general provisions, healthcare surrogate, life prolonging, which is the living will, and if you don't have an advance directive, so I won't give you all the sub numbers. Now, 765 talks about an advance directive. In my world, advance directives include the powers of attorney because, again, I fold financial and healthcare together. But advanced directives are probably better described as just healthcare. 30,000-foot view, we have an advance directive appointing a healthcare surrogate. We have a living will, which is the document in which you express your end of life decisions. We have a situation if you don't have a living will. We have a situation if you have not executed a healthcare surrogate, a designated healthcare surrogate. And then there's also in the advanced directive statute in 765, anatomical gifts. I'm not going to get into anatomical gifts, but I wanted to go briefly through the other parts of the statute. And I have to put on my glasses for this because my reading is not going to do real well about that. All of the documents that we're going to talk about, in other words, the designation of a healthcare surrogate and the living will, can be revoked or terminated by the principal, and the principal again is the person making the document, in the same ways that the power of attorney could be. So by written, please don't do it orally. It's almost impossible to prove that up, but pretty much the ways we talked about for the power of attorney. So, and it's important to document that and to communicate it. So let's talk first about the healthcare surrogate designation. And here's where I wish they had said healthcare agent, but in Florida, we call it a healthcare surrogate. A healthcare surrogate is the person who's going to make healthcare decisions for you. Healthcare decisions is defined in the statute, and this is basically the person that makes medical care, provides informed consent, but it's also the person who's going to get your medical records. It is going to be the person that interfaces with care managers who might decide what prescriptions you get and don't get. And so it's a very important personal care decision maker. The statute allows you to choose a healthcare provider who is a healthcare surrogate who is different for mental health. That's okay. And it's understandable because you might want a healthcare surrogate who's different for mental health purposes. So when does a healthcare surrogate kick in? This is the efficacy. Well, I guess I'll go back to who can serve as healthcare surrogate. Anybody over the age of 18 who's competent. Most people don't choose institutions to serve in this capacity. There are some, and I do have care managers who will serve as healthcare surrogates because more and more we have people who have no family, and that can be tough. So care management companies, nurses sometimes will serve as healthcare surrogates, and that can be really tough. You can have co-surrogates, you can have successor surrogates. I like to have surrogates where we say one or the other, because then if we can't reach one because of cell phone unavailability, I can roll it over to the other. A healthcare surrogate is going to be the person who makes routine medical care decisions for you. People always jump in their minds to end of life care when I talk about healthcare surrogates. That's usually not what we're talking about. We're talking about you can't make your own decisions because you've had a major operation and you're just too out of it for 6 weeks to make routine medical care or healthcare, personal care decisions. This is the person who's going to make those decisions for you, and then you're going to pick up and run with it after you get better. Now, the surrogate can play a part in end of life, and we'll talk about that in a minute. But generally speaking, this is routine medical care. And so it's important to keep that in mind when you choose a surrogate. The other thing people say oftentimes, and this applies to the power of attorney as well as the surrogate, they say, well, I can't possibly choose my brother. He's 3 years older than I am. I encourage my clients to think about the fact that when we do this type of planning, we are all thinking 20, 30 years in the future. Well, for me, maybe 10 or 15, but what we ought to be planning for is what if something happens in 6 months? So I say, go with your gut. Pick the person, even if it's your brother who's 2 or 3 years older than you are, pick the person that you'd want to rely on if something happened to you in 6 months. And that's particularly true of healthcare, because you can always change these documents. They're amendable, changeable, revocable, and it's easy to do. So that's basically anybody can serve as a healthcare surrogate, but it needs to be the right person. So let's talk about the efficacy of the surrogate. When does it become effective? And you have 3 options in Florida. You can have a doctor say that you can't make your own decisions. There are a couple of options there. Relatively recently, the legislature gave us a 3rd option, and this is my favorite option, barring some unusual circumstances. The legislature now says that I can pick an option that says, I want my surrogate to have immediate access to my healthcare records and make decisions for me, provided that as long as I can make the decisions, I make them. This came about because we were running into problems with, I'm in a minor fender bender, I'm beat up, I'm clearly not able to make any decisions. I'm lying in a gurney in the ER or in a hallway, and they can't find a doctor to come down and say, I can't make a decision. Or I'm at home, I've had a bad case of the flu, this is before COVID, I'm out of it, but no doctor will put in my chart that I can't make decisions, and my spouse or my daughter needs to make decisions. Awful situations, but I couldn't, under Florida law, my surrogate couldn't take over until a doctor said I couldn't make decisions. So we now have an option that allows me to say, I keep decision making, but if I can't, I don't have to wait to find some doctor. By far, my preferred choice and most of my clients. Okay. So once we decide what the surrogate can do, the surrogate, again, the surrogate's authority can be revoked. The surrogate's authority is going to terminate, again, much like the power of attorney. The surrogate dies, the surrogate resigns, the principal revokes it. In some cases, the surrogates, well, if the principal regains capacity, then it stops and notice needs to be provided. If the surrogate is in a facility, the facility has to provide notice of the incapacity statements. Now, I find that it's very, well, let me talk about notice for a minute in the surrogate context. When you sign a power of attorney, you have no obligation to give that document to anybody. There's no legal obligation to do it. And in fact, with many of my clients, because it's such a powerful document, they don't give it to anybody. They stick it in a safe in their home, and they say to their agent, particularly when it's children, adult children, they say, you know what? I've named you to help me with my finances, but this is where I keep my important documents. So if I get in a car wreck, go find those there. But with a surrogate document, you have to give a copy of that document to your surrogate, your named surrogate. That's a notice requirement under Florida law. So in our surrogate documents, I think it is critical to outline in the document what the surrogate must do and what the surrogate can do, because really we're speaking in that document to the surrogate. So I wanted to go over that a little bit because many of us are named as surrogates for spouses or parents, if we still have parents living. It's intuitive to think, well, the surrogate makes medical decisions and provides informed consent. But what does that mean? Remember with the power of attorney, I said that the agent had to make decisions that were in the best interest of the principal. Okay, not so with the surrogate. What does that mean? With a surrogate, the surrogate must make decisions that the principal would make in that situation. It's a different standard, best interest versus substituted judgment. So if my daughter is my surrogate and I'm out of it, and the doctor is recommending a type of procedure that my daughter knows I would never under any circumstances undergo, my daughter cannot authorize it, period. Really scary stuff, really scary, but that is the standard. I am my daughter, as my surrogate, can only do what I would have done under similar circumstances, unless there is no evidence of what I would have wanted, in which case my daughter shifts back to a best interest standard. Now that can be, a sticky wicket, but that's the standard. And you can be held to this standard. There have been court cases to be held to this standard, but be careful about that. And when I'm advising clients should be advised, don't pick the eldest child or the spouse if they're not going to hold to that standard. In my family, my husband and I have been together almost 43 or 44 years. I've lost count, but his solution to all medical care is take her out to the South 40 and shoot her. Well, guess who's not my surrogate? Okay, enough said. So that's a standard. Now, obviously, the surrogate's going to consult and consent and provide input as to diagnoses, et cetera, et cetera. They can provide and withdraw consent. And if we get to end of life and I don't have a living will, the surrogate, unless it's prohibited in my document, can provide advice and consent as to end of life. They can provide consent as to mental health treatment. This is relatively recent. A surrogate can sign do not resuscitate orders. And a do not resuscitate order, remember, is different from a living will. We can talk about that in a little bit. They have access to and can release medical records and other information, including mental health records. This is probably a good time to pause and remember that the surrogate does not have access to write checks, but to the extent required, does have access to financial records to the extent it's necessary to perform their duties. The same way the power of attorney has to have access to medical records to perform his or her duties. The surrogate must apply for public benefits to the extent needed, and must have access to information to file those applications. They can put somebody in a nursing home subject to certain requirements. They can employ professionals, but only with the help of a power of attorney if they're not the same person. They have to coordinate and things like that. So the surrogate really is your stand-in for your medical and personal care. Okay, let's talk about the living will, because that's usually the 600-pound gorilla in the room when we talk about healthcare. And I know that most of you are familiar with a living will. That is your expression of end-of-life care. Do you have to have one? No. It is not required under Florida law. I tell my clients, I really think you must have a surrogate designation. There's really no reason not to have a surrogate designation, but you don't have to have a living will. A living will is a document that is a creature of primarily of statute, to a certain extent of case law in Florida. Again, all of this is very state specific. So a living will in Florida is your expression of end of life, but it is activated only under very specific circumstances in Florida. And so let's talk about those. So a living will only spring to life, so to speak, if a doctor says, a primary or attending physician, they're called evaluating physicians, I think, in the statute. That doctor has to say that you cannot make your own medical decisions and you're not likely to recover. So this isn't just if I go in for minor surgery and I'm under anesthesia. But I'm not likely to recover that ability. And in addition to that, two physicians have to say that I am in one of what Florida calls 3 trigger conditions. I have to either or, because many times you're in one or more of these, either be terminal, 6 months or less to live, or a persistent vegetative state, which to us lay people is like a coma. All of these are defined in the statute. Or the very end of the truly debilitating diseases. They're called end-stage conditions, Parkinson's, Lou Gehrig's, Alzheimer's, some of those. And again, it's defined in the statute. If and only if all of those conditions are met, then my living will, if I have one, is activated. And the living will is the document that says at that point in time, I want life prolonging procedures withdrawn or withheld. Now, the life prolonging procedures is generally defined as things that will, it can be artificial hydration and nutrition. And this is where I tell my clients, and I do have definitions for that. We have them in our documents, but they're those things that lawyers love, like including but not limited to. And I have a JD, not an MD. I'll remind you of that again. The key thing is that you should work with the drafter of your living will to make sure that when it comes to these issues, it is as specific or not specific as you choose. And that you are very clear that even if you want life prolonging procedures withdrawn or withheld, you want all pain and palliative care continued. And I will tell you that it's been I try to keep up with the palliative care industry to a certain extent, just because I'm interested. It has changed hugely over the time I've been involved in this. I was on the board of Big Bend Hospice for almost 7 years, but it's been 10 years since then. And the way that the palliative care industry has changed, it's marvelous, because it used to be that you wouldn't get kidney dialysis even if you were dying of brain tumor, but now apparently you can get dialysis if it'll help your quality of life, if the brain tumor is going to kill you. And I mean, don't quote me on that, but it's just humongous steps. So you need to work closely with your healthcare provider and your lawyer in drafting these documents. There are limitations on the authority of the healthcare surrogate. There are certain things the surrogate can't do in relation to pregnant women. The surrogate's authority can be suspended and will be suspended upon a filing of incapacity, the way we talked about earlier. Their surrogate, I get the question all the time, well, if I act in reliance, am I at risk? And generally, no, if you act in good faith. There are very few actions against surrogates in today's world, unless you're really out there. And it really is pretty hard. Very few criminal actions anyway. Now, let's say that we have that sister or brother that flies in from out of state and says, oh my gosh, you're killing mom, or mom would have wanted that crazy treatment. There, obviously, time is of the essence with these cases, and there is an expedited court proceeding that we can institute. We can get into court within hours if we need to implement a living will or a surrogate matter. After Shivo, we had to do that fairly frequently. Our firm was involved in Shivo, and we don't have to do that much anymore. So I see I'm running out of time, so I better shut up, right? You should have told me, Neil. I love to talk, in case you couldn't tell.
I could go
on.
I think everybody else enjoyed your presentation. Okay, so happy to open it up now to some questions. There are some in the chat. I'll read them fairly quickly. From Susan Poplin. This is with respect to the first part of the presentation. Yes, even with original notarized DPOA, our bank required bringing grandmother to the bank physically. Is that typical?
No, it's not typical, and they should be strung up by their you-know-whats.
Fast answer. Thank you so much. From Kathy, does the healthcare surrogate need specific authorization to file claims with my health insurance company? Does the health insurance company need prior notification?
The healthcare surrogate shouldn't. No, but it should be described in the healthcare surrogate document. Now, they may need the power of attorney document need to be specific, and it may need to be filed by both.
Okay, that was it for the chat questions. Let me open it up for any others, or people can type them into the chat as well. But either way, feel free to start answering questions. while we're waiting, I wanted to mention a study I once read that was relevant, I guess, to health surrogates status. People studied what the person, that is, in this case, the elder, would have considered as appropriate end-of-life treatment, and then independently asked, for instance, their children, what do you think mom or dad believes as appropriate end of life? And there was very, very little agreement between those two groups. And so I think maybe, Lauchlin, you want to comment on that briefly while we wait for other questions?
I've had those discussions as well, and it's amazing the divergence. Well, and if you think about it, what I said I would not put up with when I was in my 30s, to the extent I thought about it, and what I might put up with now, man, my knee hurts all the time. My shoulder's out, you know, I put up with that pretty well. And it's amazing. The other thing that if you talk to EMTs, emergency medical techs, people who are on the floor gasping for breath and, oh yeah, take me to the hospital, when they might have something else on them, it's different. Now, do canceled checks count
as legitimate receipts to document spending?
Yes, anything like that. Yes, you don't have to get a satisfaction or anything. And I don't know if we have time, but many people don't understand the difference between a living will and a DNR.
Yeah, and we have a couple of minutes if you want to quickly.
Yeah, a do not resuscitate order is a doctor's order saying that if you have a cardiopulmonary event, a heart attack, you're not going to be resuscitated. A lawyer can't draft that. You have to do that with your doctor. And the living will, however, is something your lawyer can draft. The other question I get a lot is about the 5 wishes document, and the 5 wishes document is a perfectly legitimate document. I'm a big proponent of that. The main difference between the 5 wishes and what I, for instance, draft is the 5 wishes has a lot of precatory language in it. I wish to have music. I wish to have. I don't put a lot of that in my documents. Mine's more legally driven I can't imagine why. The other thing is that my healthcare surrogate document has a lot more, is a lot more descriptive about what the surrogate must do, can do. And the health 5 wishes document doesn't have as much of that in it.
So on behalf of everyone today, let me again thank you, Lauchlin, for coming out, talking in our brown bag. And thank you as well for helping us on ISL's Community Advisory Board. And thank you for all the people who came out to listen today. We hope you'll be able to come out to other brown bags in future. Thanks again, and goodbye for now.